This is LXBN TV, and I'm Colin O'Keefe. The Supreme Court ruled 5-4 last week to uphold the Patient Protection and Affordable Care Act's individual mandate, with Chief Justice John Roberts being the deciding vote. It was a move that surprised many, and to offer his thoughts on why Roberts may have went the way he did, we bring in Max Kennerly, attorney in Philadelphia with the Beasley Firm and author on Litigation and Trial. Max, first off, where does this ruling fit in with what we've seen from John Roberts and the quote John Roberts court?
Well, it's always interesting to talk about how a ruling fits in, because usually if you want to think about what a ruling means in terms of the court's prior precedent, you kind of look at similar cases. And when you're talking about the Commerce Clause, you're not really talking about that many cases. You go back 1945, there's Wickard, there's then the two opinions under the Rehnquist Court, then there's the Rake opinion, and then you're done. That's it for the Commerce Clause. So, that's its own issue. And then when we get to this tax issue, it's a blank slate. I mean, both sides of the court talks about things of, well, we have this in our precedent, we have this in our precedent. Well, truth is, not a lot of taxing power cases out there one way or the other. So when you look at it as how does it fit in, one interpretation you can have is, well, Commerce Clause, Roberts' opinion, now it's just an opinion. It doesn't really stand on its own, considering that, the dissent from the four conservatives is not joined with his. So you get this kind of strange plurality decision where a majority of the court says it's unconstitutional under Commerce Clause, but you don't actually have that nice majority opinion for it because they divested on that. So where it fits in is, we've had this long conservative strand over the last couple of years towards, last couple of years, kind of like 20 years, towards reining back from that Wickard post-New Deal view of the Commerce Clause. And in that sense, it fits right in. And a number of scholars have been talking about this of, look, we need to, I should say conservative scholars. Liberal scholars say, look, under Wickard, you're pretty much done. Almost everything's going to work. A number of conservative scholars have been reining that in, saying, well, wait a minute. The federal government is supposed to have limits in its ability to regulate commerce, and this seems to stretch beyond how the framers would have interpreted how it should be interpreted today. So when you look at that component, well, it's just a continuation of this conservative movement to limit the Commerce Clause, and that's why you have a number of conservatives saying, we want everything except the case. And in many ways they did on the Commerce Clause. But then you've got this tax issue. And, This comes back down to the Marbury versus Madison that you learn in law school, which is, people in college, people generally aware of the law, they learn of Marbury versus Madison as upholding, this idea of judicial review. It's a little more subtle than that. At the end of the day, what Justice Marshall did in Marbury versus Madison was to rule, well, we have the power to look over all these statutes, and we are the supreme power in the United States to interpret the Constitution, but in this case, I'm really sorry, we can't help you. And, in time, over history, people have looked at that and said, that's just a little bit too pat. The opinion itself says there's no right without a remedy. And then that's the holding. The holding is, you know what? We can review this statute. We can strike it down. We can't actually finish delivery of these certificates, the actual issue in Marbury versus Madison, so that they lost. And the underlying subtext of that is, he had already been told by the executive branch, if you make us deliver those certificates, we're not honoring you. And it was a constitutional crisis. So John Marshall found this slalom to get through it, affirming his own power, while not actually causing this constitutional crisis by deferring and saying, look, we're not going to order the executive branch. And a lot of people have come back around and said, you know what? John Roberts did the same thing with his taxing power of he let this act go through, but he let it go through on a very narrow framework, and he continued this Commerce Clause limitation, instead put it in tax. Now, that's one that, over the next couple of weeks, next couple of months, we're going to get a lot more discussion about that, because, interestingly, you have some liberals who are arguing, you know what, John Roberts is still continuing his limitation on federal power, and then you have some conservatives, John Yoo recently had an editorial on this, where he said, wait a minute, this limitation is nothing. If the government can tax you to make you buy healthcare insurance, it can do anything. So we kind of have to see how that one plays out. But that may have been the I don't want to say trick, but that may have been kind of the maneuver here. It's similar to Marbury versus Madison. If I don't want to touch this, I don't want to create any type of constitutional crisis here, but I'm going to preserve the court's power to review these types of statutes.
Definitely, yeah. I thought it was really interesting. It's going to be interesting to see how that labeling as a tax impacts things in the coming weeks and months. So I saw you offer a few comments on Twitter on this subject as this ruling came down. But why do you think Roberts ended up going the way that he did? It seemed like there was evidence to suggest that he may have done so at the last minute, but it was a very interesting outcome for him. So why do you think that he ended up ruling in favor of upholding the individual mandate?
Well, it's interesting you mentioned Twitter because one of the things I put out before the opinion was somewhat criticizing John Roberts because of his, in my opinion, callous attitude towards individuals in general. And so, of course, after the opinion came out, and Roberts was the one who was helping uphold its constitutionality, noted tort reformer Walter Olson called it my exploding cigar moment. Now, we've learned a little bit more since the opinion was released on what may have transpired there. And initially when the opinion came out, you had a couple different scholars look at it and say, you know what, this dissent from the four conservatives, it looks like a majority opinion. And it gets written as a majority opinion. And it references solely Ginsburg's dissent. It's as if, that opinion's written completely ignoring Justice Roberts' own opinion, the one that actually carried the day. And so, we've seen a little bit more of apparently, from what we can gather, and of course this is kind of looking into the crystal ball, what we can gather, Justice Roberts was initially in favor of striking it down on constitutional grounds and then switched his vote somewhere in there. The big question is, of course, why? Now, we talk about the court today. Like people seem to say, or people resist the idea that the court is purely political. But when we look back in history, we have no problem saying this about prior decisions of the court. Like, we look at Dred Scott and we say, well, that was just terrible. Justice Taney, he ignored the Constitution. He was making a political decision. We look back to the New Deal and we can say, well, they switched their vote for the court packing scheme to avoid that problem with FDR. I think we should try to take a little bit more of that same type of framework to today, where you either get half people saying it's all purely legal and half people saying it's all purely political. Well, they're not fools. They're not political hacks. Like, politics informs the Supreme Court's opinion. Now, we need to look at it in the present tense of how did politics inform the Supreme Court here? And, there was actually a recent paper by Lee Epstein and Andrew Martin on if the public opinion sways Supreme Court decisions. Now, this has been kind of a lingering question. Back in the 20s, Justice Cardozo said that judges are not immune from the currents and tides that sway the minds of men. Well, that's always obviously been there one way or the other. And at least in my view, when you look at this, Justice Roberts was probably keenly aware of the fact that the Supreme Court has fairly low standing these days. And it's not just among people blathering on CNN or MSNBC or Fox News. It has low standing among the public. And, I think this signature piece of legislation by the president, one that included extremely popular provisions, the individual mandate, it's not a really good sell. Nobody really likes the individual mandate. Pre-existing conditions, completely other matter. That has widespread support for it. Now, when you get into this deeper insurance argument, you can't really have, a pre-existing exclusion prohibition without also having something that makes everybody buy insurance. So I think Justice Roberts, looked out there and realized if they overruled this one, they may have prompted another constitutional crisis. I mean, Obama hinted at this. Was he really thinking it? I don't know. But he hinted at running against the court. And, everyone kind of gasps at that of, well, how could you dare run against the Supreme Court? But look, it was established as a political body. It's not a bureaucratic body. It's a political body. There's a reason the framers set up the way they did. So, once I think Roberts looks out there and realizes what's coming if they rule it unconstitutional is a political attack on the court, specifically a political attack on him, and questions of his legacy down the line. When a lot of people look back at legal history, they don't talk about this justice versus that justice. They say things like the Taney court. Yeah. And I think, then they refer to his predecessor, the Rehnquist court. You don't really talk about O'Connor. You don't really talk about, the role Scalia played in pushing parts of the Rehnquist court. It's the Rehnquist court. And I think Roberts looks at this of, is my legacy going to be the Roberts court is the one that struck down for the first time in 3 generations the president's signature legislation and got the entire public inflamed and angered at the Supreme Court, which already had low standings. I think he looked at that. I don't think it's a matter of, he bowed to the threat of political pressure. I think he looked at that and looked at the Supreme Court in a much larger context and said, you know what? I'm not going to do this for this court. And, I think people can say it's a technocratic view one way or the other of, well, this was just his genuine feelings on the tax clause. But when you look at the Roberts Court, they don't really have any problem going beyond or underneath the types of questions presented to them. I mean, Citizens United was the classic example of they went way beyond the question that was actually presented to them. And, from the reporting we see on that, Jeffrey Toobin had a piece in the New Yorker, it seems that Justice Roberts was the driver of that, of pushing Citizens United from this really narrow regulatory case to this broad question about the First Amendment in general across all corporations and all unions. So, I think he looked at that of, what is going to be my historical record? What is best for the court at this moment? And I think he looked at that and said, we can't do this. If we do this, we are going to seriously threaten the court. We're going to threaten the Roberts Court legacy, and we're going to threaten the legitimacy of the Supreme Court in the public's mind.
Mm-hmm. So, this obviously has huge implications for the Roberts Court, but do you see them reverting back? I don't want to say to their old ways, but how do you see this affecting the court going forward, and then much more broadly, some of the political landscape coming in the coming months and the coming years?
Well, when you look at the opinion itself, and it sounds unusual to think of this way, but a lot of scholars seem to already have this opinion, which is, in terms of the law, it's kind of a non-event. If you look at this interpretation, and what other case are we going to have in the next generation that's going to look anything like this? What other case are we going to have that's going to overhaul the entire healthcare system, which is one of the biggest costs of all of society? When you stop and think, what could be bigger than this? What could even be equivalent to this? And so, it's in some ways it's similar to Bush v. Gore. There's good chance that this is a one-off opinion that nobody's going to refer to down the road, which isn't going to change the law down the road. And I think, in terms of what it does in the future, maybe there's a question about this taxing power issue of, is John Yoo right that this taxing power opinion by Roberts has now opened a whole new swath of government power? Or is, like some of the other conservative scholars on it, correct that, look, we won the argument. We just didn't happen to win it in this particular case. But going forward, Commerce Clause is reinvigorated, has a lot more powers. My personal view is this opinion, to the extent this makes a difference in the Roberts Court going forward, like outside of the healthcare itself, but the Roberts Court itself, maybe it's strained relations. Now, what does that mean going forward when you have strained relations where the Chief Justice is a conservative and does not get along with the other four conservatives, or they blame him? I don't know. You had a lot of Supreme Court histories that talk about the role of relationships one way or the other. I don't know if it makes as much of a difference as it did in the past. Brown versus Board of Education, part of what made that opinion so important and so notable was the fact that they were able to marshal unanimous per curiam opinion for it. Now, it doesn't seem the Supreme Court really cares as much anymore about having this type of unanimity on everything that they decide, to have these type of per curiam opinions that, look, this is the law. We all agree on this. They're more than happy to have 5-4 opinions. And the Roberts Court had plenty of these 5-4 opinions on very serious issues. The First Amendment union dues case, extending Citizens United to all these state anti-corruption laws in Montana, the strip searches of everyone arrested because they didn't have a bell on their bicycle. And this is one of the actual cases. So, does it really matter if Roberts now has a little bit of a strained relationship with Scalia or Alito or Kennedy, who was apparently one of the ones lobbying Roberts to come back into the fold? I don't know. My impression, though, is that after they take the summer off, they cool off and they come back down to business, what we're going to see is essentially the Roberts Court on the same path it was prior to this decision, which was a very conservative court, which was very aggressive, which took cases in front of them and decided them as broadly as they could possibly imagine to do it. So, I think what happens after this point is Roberts will be strengthened and will be emboldened by the fact that, look, he's established his apolitical bona fides in the currency of the American public. And so I think, next time around, we're probably going to have what we've been having with the Roberts Court ever since Roberts was appointed, which is a fair number of 5-4 opinions on very serious issues. And that's, I think, going to be kind of the return to equilibrium before of Kennedy's the swing vote, not Roberts.
Yeah, that's going to be interesting to watch once they go back there. Because, I think you said he's kind of gone to measures to establish his legacy. He's got it in place, and now he can kind of go back to doing what he's done. And that's what's going to be interesting to watch, is to see what impact that has on some of these very, very serious cases. Well, once again, that was Max Kennerly of the Beasley Firm and his blog, Litigation and Trial. For more of his insight, be sure to check out his publication. It's again at litigationandtrial.com. And for more video interviews, be sure to check us out at lxbn.lexblog.com. Thanks, Max.
Thanks, Colin.